Can we start now, sir?
Just a minute. Yes. Vivek, yes, start. Good evening, friends. I extend a very warm our panelist and participant. Today, this is our 39th webinar. We are trying to select the topic which are where corporate India has maximum queries and issues, and the topic is more complex. We try to invite views. If some issues are still unanswered or some confusion is there, we refer these points to the regulator so they can issue clarification. Today's topic is also very interesting. That is the beneficiary, the significant beneficiary ownership, SBO, which we are talking. It is a most complex subject and it has a multiple interpretation and issues. This law is no doubt is complex, but when we discuss with Ashwini Taneja ji, who is our today's panelist, then he has added one more angle about the Benami Property Law also, which is there. If some ownership is not clear or doubtful, then it will come under the Benami also. And the SBO start with confusion and it rests with Benami law. This SBO issue is almost very important and confusing, and Benami Property Law has added some more flair into this. Today we have invited Ashwini Taneja ji. Ashwini Taneja is our partner, and Ashwini Taneja is a former member of Income Tax Appellate Tribunal. He is well qualified. He's a CA, CS, CWA, and fellow member of Indian Council of Arbitration and LLM. He has wide area of experience. Since '95, he's practicing as a chartered accountant. Then he started practicing as a tax advocate. In 2015, he joined a member of ATA and he posted in Mumbai bench. And I think during a very short period of 2 years, Ashwini Taneja ji has delivered 2,000 judgments on various issues, including various top judgments also. After 2017, he resigned and he started again as a RRA legal and started practicing income tax and Benami law and PMLA and appearing various adjudicating authority, High Court, Supreme Court, and other places. Today, he is one of the experts in India on Benami and PMLA law. He has given interviews on various topics of income tax and budget and various TV channels. Number of landmark cases argued by him. He has given so many lectures also, and his integrity and expertise on subject. I welcome Ashwini Taneja ji for this program. Then we have Mr. Sudhakar, S. Sudhakar. He is qualified company secretary and chartered accountant. He is vice president, corporate and secretarial at Reliance Industry. And today we will definitely get benefit of Sudhakar's presence in this program because Reliance is one of the biggest company in India and multiple company and so many shareholders are there. So we'll get benefit. Sudhakar is a vice chairman of Secretary Standard Board of ICSI, and he has been a member since 2016. He was a member of Vision Committee ICSI 2022 from 2017 and 2018. He has a very wide exposure and experience in various facets of corporate and security law and is sought after speaker in various programs on professional. I welcome Sudhakar ji. Then we have Ankit Singhi, who is a partner and head corporate affairs and compliance in corporate professional. Ankit is one of the youngest panelists here and very upright professional. He's expert in company law. And he works in this, and he has written various books, delivers various lectures. And the most important thing, his flair to understand the IT and law, that is very important. And he has worked in various IT related things, which is how to solve the problems of the corporate by providing IT solution. So I welcome Ankit for this program. So friends, today we 3 speakers are there, and our program is structure is like this. Ankit will give Ankit will start, and he will give the basic concept, genesis and analysis and impact under Companies Act, and he will tell you about the SBO, that how things will move. So today he will cover various aspects. Then I will request Ashwini Taneja ji. He'll give overview of the Benami property and how the Benami property is connected with the SBO, because I told you where SBO rests, the Benami law starts. So he will tell. Then I'll request Sudhakar to explain about his experience, how he is managing this issue and what are the problems they are facing. And then we will start question answer. So anybody has any question, you can give it to, you can write to us, and we will take up. Some questions we have already received that we will ask. Another question you can give. My request to all of you, don't send multiple structure, because when I will explain to the speaker, he may not be understand and the answer will not be there. Ask the question, not the structure. That will be very good. We have received. We will try to answer some of the questions. Today, when we will start this topic, the coverage is so many things we have to discuss. We have to discuss the directly and indirectly, body corporates, partnership, LLP, trust, because all these entities are there where SBO will come. Then we will talk about the significance, control, holding. The interesting point is where the Benami law comes, holding with or holding through. That is the most important differentiator, where Ankit and Ashwini will tell us. Then obligation of SBO. What are the obligations he has to declare? How the form Ben 1, 2, 3 will file? How the disclosure to stock exchange? Obligation to reporting companies, because that is also very cumbersome process. How to identify how much, when to give. And here we will take experience of one of the biggest company in India. Then what are the consequences if we are not following this? How to do this if this is open end, whether the money will transfer or the shares will transfer to IEPF, how to get back this, how to claim this, that is another aspect. What are the exemption and other aspects we will cover in this. Friends, when this new concept came of SBO in 2013 law, but implemented later on, there was too much holla in India, and everybody was telling that this is a new concept. But no, friends, the worldwide it is happening. If you are forming any company in any part of the world, they are asking, who are you? Who are behind this show? And this is really very complicated and complex system. Earlier, we have a 187C 2015 Act, 2000. Now this is a 90, which is direct and indirect concept is covering. I remember very interestingly, when I was doing training as a company secretary, I went to one company for doing audit. And in the audit, in that place, nobody was there, only one peon was there. And I went there, they gave me the data room and I was doing. So after 2-3 days, I told him that please please call the director. I want to ask certain things and I have to take some signatures. So the person told me कि डायरेक्टर साहब कल तो आए थे पर आज छुट्टी पर है. तो मैंने कहा ऑफिस में तो मैं ही था अकेला और ये था जो बच्चा मेरे साथ काम कर रहा है और एक पियोन था और तो कोई था नहीं. पर मैंने कहा ठीक है जी, कल आ जाएंगे तो दिखा देना। नेक्स्ट डे वो डायरेक्टर साहब आ गए। वो डायरेक्टर साहब कौन थे? वो जो कंपनी में प्यून थे वही डायरेक्टर साहब थे। तो आई वाज शॉक्ड एंड आई वाज थॉट कि हाउ दिस इज, दैट वाज माय फर्स्ट audit assignment as a trainee. I went there. So that was happening. So you have seen so many companies as a director who are holding shares, as a who is holding shares, driver, peons, and various people. So this is happening in India. So somebody is having a ownership, but the control and the legal ownership is with some other person. So you can find that this is happening, and this is not good for any orderly society, orderly corporate world. So this is happening. Now come to the structure. The structure is so complicated. Ankit, can you just share? If I can share one slide to you, then you can realize that we are doing work of various companies and identifying that who is doing this. Now this is one slides you can see. This we have done a structure of one company. Now by seeing this slide, you can understand this is some बिजली का कनेक्शन का जैसे मकान बनता है उस तरह का कनेक्शन है, but this is not. These are all companies on the top, and who is holding and what is holding, and we have to reach who is the owner of this company and where is this person. So you can understand this type of structure we have. So government came out, they restricted the first they told that you don't have more than 2 layers. Then they restricted in the other sector. So this type of structure, how you can reach to that level, that who is having what shares, and all these problems are there. Ankit, okay, just close it. Okay, so this is happening, and this way things are so complex, and this process you are reaching to beneficiary interest. So now this is a very complex thing. Government has realized this. That's why they have restricted. That's why they want who is ultimate beneficiary, but the complex subject, how to simplify it. Now I will request Ankit Singhi to give law section 90 section and how it is implementable, how these are things. Over to you, Ankit.
Thank you, sir. Just a second.
In the meantime, you can send your queries so we can use it.
So, as mentioned by sir, that this concept was already prevalent in Western countries, in Europe, and even in Singapore. But this concept was originated statutorily. It received the enforcement when Financial Action Task Force, FATF, the statutory body across the where most of the countries are the member, who looks into terror financing, money laundering, and other related activities, they coined this term of ultimate beneficial owner. Ultimate beneficial owner, or the ultimate owner, means a person which they described as a person on who is the ultimate owner, who owns and on whose behalf all the transactions are being executed. That person should be treated as an ultimate owner. Taking a cue from that, SEBI and other authorities, even in the PMLA, the beneficial owner concept was there. But while the Companies Law Committee was evaluating the provisions of the Companies Act and the amendments that were required, they considered that while under the SEBI or under the PMLA, there is a concept of money beneficial owner, but there is no such provision or statutory requirement to disclose this beneficial owner to any authority. And there was already a commitment to FATF to meet these obligations of the FATF. So the committee, considering the same, and there was already a provision under the SEBI and PMLA for beneficial owner, recommended that their provision should be introduced under the Companies Act, which first of all provides the manner in which the beneficial owner in any company, the ultimate beneficial owner, can be identified. And then there has to be a disclosure from the concerned person so that the disclosure should be made, and the necessary information with respect to the beneficial owner, ultimate beneficial owner, is brought in the records of the registrar of the companies. So accordingly, in 2018, I think in June 2018, the Companies Act was amended and Section 90 was changed completely, and a new section was introduced which provides for significant beneficial ownership. So section 90 subsection 1 provides for the concept of beneficial owner. It means a person who acting alone, together, or through any persons holds a beneficial interest of 25% or such other percentage as may be prescribed in shares, or exercises or right to exercise significant influence or control. So this is the definition which was provided under the Companies Act, section 90 subsection 1. And accordingly, the rules were also introduced at that point of time. But thereafter, for a period of around 12 months or so, the concept was actually kept dormant. Because there was a lot of vagueness in the rules that were introduced at that point of time. So government keep on deferring the dates for filing the disclosure, and ultimately in February 2019, they completely overhauled the rules and brought a completely revamped rules of significant beneficial ownership. And while doing so, they also changed the definition of significant beneficial, or extended the definition of significant beneficial ownership as was defined under section 90 subsection 1. While acting alone or through other persons remained the same, but they reduced the percentage of 25% to 10%. So in terms of 10% shares, 10% voting rights, 10% dividend distribution, or right to exercise control or significant influence, because in right to exercise control or significant influence, you cannot quantify in terms of percentage. But in respect of shares, they reduce the percentage to 25 from 10, and then also added voting rights and distributable dividend. While if a person owns any shares, it would definitely got voting. It will definitely have rights to voting right and distributable dividend. But nonetheless, they added the same. And what they also provided that these holdings should not be direct. It should not only be direct, it should be either only indirect, or it should be direct or plus indirect. The question which still remains is a point of 25% or such other percentage as we prescribed. Whether the intention of such other percentage as we prescribed was to give a power to executive to provide a higher percentage of stake, or to reduce it. Logically, it should be higher because 25% is something which the Parliament has approved. Nonetheless, 10% was thereafter introduced. So what is important is this definition. While acting alone acting alone is clear, acting together is also defined. The main thing that needs to be looked into is through other persons. So through other persons is something which needs discussion or which needs further analysis, because actually the web, or where the significant beneficial or the ultimate beneficial actually hides himself, is through this concept of acting through other persons. We can find out and what would be the structures and where this will be treated as through other persons. So as I mentioned, the word used is acting alone or together. So acting together is also defined under the explanation to the rules. It says that every individual is acting through any person or trust, or with a common intent or purpose of exercising rights or entitlement, that is dividend, shares, voting rights, or control or significant influence, pursuant to any agreement, understanding, formal or informal. So the word understanding, formal or informal, gives this a one of the most widest scope of interpretation. Can be there, and it can be formal, it can be informal. Informal understanding is there where it is difficult to establish, but there is the actual where the game will be played, is to establish that there was an understanding which was an informal. If one, two or more persons act together in such a manner, it will be treated as an acting together. So it is important that acting together will not always involve relatives or immediate relatives. It can be two unknown persons, two friends, will depend upon the circumstances of the case, the pattern in which they were acting. All these will be considered while determining acting together. Then what is important is while section 90 subsection 1, while defining SBO, uses the word beneficial interest, but the rules while defining the word as a term SBO doesn't uses the word beneficial interest, but still it's an important definition to look into. So beneficial interest means a person who alone or together, directly, indirectly, through any other contract or arrangement, holds rights or entitlement to cause or cause to exercise all the rights attached to a shares, to vote, to take dividend, or to participate, or to exercise any kind of rights attached to a share, requisitioning, appointment of director, going for inspections of registers. All these are rights which are attached to any shares. So this itself gives is if any person exercises these rights, then it will be deemed that this person actually holds the beneficial interest. So in terms of beneficial interest and beneficial owner under section 90, I think that there is a very thin line difference, because most of the beneficial owner will, in one way or another, will exercise beneficial interest. But all the persons who exercises beneficial interest might not be the beneficial or owners under section 90, because there is a eligibility criteria of at least 10%. So you may be SBO, and if you are an SBO, you must definitely be exercising beneficial interest, unless otherwise you're exercising only through control or significant influence. But if you are exercising rights through voting, dividend, or shares, then you would deem to be having beneficial interest. And if that interest is 10% or more, then you automatically becomes a SBO and your declaration is triggered. One important thing that needs to look into is that the term which is used is shares, and the law defines shares. The rules defines what is share. So share means shares. GDR, compulsory convertible preference shares, compulsory convertible debentures will be treated as shares. So considering this definition, it means any equity and the instruments which are mandatorily convertible into equity are only treated as shares. So preference shares, even if they have voting rights, will not be considered. Differential voting rights, then voting rights will have to be calculated as per the terms of the share. Optionally convertible instrument will not be considered. But even in case of compulsory convertible instrument, the question arises that if you calculate the shares, whether the calculation needs to be done on diluted basis or not. If this needs to be calculated on diluted basis, should I be giving an intimation or declaration at this point of time for shares for equity shares which I actually get after 3 years or 5 years? So I don't know why the regulator, why providing this, included this instrument, because this instrument is not equity at this point of time, and this will be converted in equity. But I think the declaration should trigger at that point of time when the equity is there. Further, what is also important, that in case of compulsory convertible instruments, where the instrument will be converted into equity at a future date and at a future price, where the ratio is not yet defined. The ratio will be triggered when the valuation will be done at the time of conversion. In such case, it is impossible to calculate even the actual number of shares that you will get out of this compulsory convertible instrument. So these are some of the fundamental issues in respect of the definition of the shares. And I believe that only equity shares which are existing at the date should be considered, and compulsory convertible debentures or preference shares should not be. But this needs to be further clarified by the ministry. So in terms of permutation as combination, as I mentioned, if you're holding direct holding, there cannot be an SBO. Yeah, if there is an indirect holding, then there can be an SBO. And if you're holding both direct and indirect holding, then also there can be an SBO. How you will determine what is direct and indirect? So direct is very clear. If your name is entered in the register of members already, or you have filed a declaration under 89, then it will be deemed to be a declaration under, if you're already holding the shares or the rights or entitlement directly. Indirectly is when you are held as an individual, you're holding shares through some medium, like a body corporate or HUF or a trust or a partnership or a LLP or a pooled investment vehicle. Actually, the problem is to identify the SBO in these cases where the shares are held indirectly, because if you see, in case of body corporate, HUF, trust, LLP, partnership, there is no individual who is at the front. The individual is at the back. So you need to identify who is the individual who is sitting at the back and who is actually exercising these rights and entitlement through these structures of body corporate or HUF. So I'll just take a couple of minutes to define how these structures work. So in case of body corporate, it is very clear. The law says that any individual who holds majority stake in such body corporate is the SBO. So in this case, X Limited, Y Limited holds 10% in X Limited, A holds more than 50%, then A is a SBO. Similarly, if there is a company in which another company is holding 10% and there is an ultimate holding company of that company, then we need to see this beneficial 50 in the ultimate holding company. So here, if you see, Z Limited is the ultimate holding company and A holds 75% in Z Limited. So with respect to shares held by Z Limited and X Limited through Y Limited, Mr. A will be the SBO for the 10% stake held in X Limited. So it is very simply based on the concept that where there is a company, any person who owns majority stake in that immediate member or the ultimate holding company of that member will be the SBO. Whether that member can be deemed to be a SBO only when he is holding singly or jointly, we'll see how that is done. Similarly, in case of trust, there are three different trusts that are prescribed. First is a specific trust or a discretionary trust. So a discretionary trust or charitable trust is a trust where the interest or the share of the beneficiary is not fixed. It is variable. It is not outlined under the trust deed. In such a case, the trustee will be the SBO. If there is more than one trustee, all the trustees will be deemed to be the SBO. But in case where there is a specific trust means where the shares of the beneficiaries is outlined in the trust deed, specific percentage is outlined, then in this case, all the beneficiaries will be treated as a SBO. It is important to note that in terms of beneficiaries, you need not to look into their individual stake. For example, one beneficiary is holding 5% and another beneficiary is liable to stake of 95% in the trust interest. Then the disclosure of both the beneficiaries will be made, not only of those who is holding 95%. Even 5% interest holder will also be required to be disclosed in such a case. The only question comes in case of a trust is that where the trustee is actually a body corporate, like a company, like a LLP. This scenario is actually not defined or covered under the current rules. So there is a requirement of clarity. But if I look into the ultimate objective of the SBO, and then I need to apply the same rule that I apply on a trust. And if there's a trust, the trustee is a company, then I should look into logically, I should look into who exercises or who holds majority control in that company. If there is such person who exercises majority control or majority voting in that company, I think that person should logically be treated as a SBO. While the rules are silent on this, but considering the intent and the objective of the declaration under this section and the rules, such person should be making a disclosure under the section 90. Partnership LLP, very clear. In case of partnership LLP, only all the partners will be treated. Here again, irrespective of the shares of the partners in the partnership firm, all the partners will be treated, or all the partners of a partner LLP will be treated as SBO in case the partnership LLP owns 10% or more shares in any company. In case any of the partner is a body corporate, then the same status will be applicable. Majority stake in that body corporate, then that majority stake will be treated for defining the person who would treat it an SBO for that purpose. So other partners will be there, and the partner who is a body corporate, then the person who holds majority stake will give disclosure along with the other individual partners of the LLP. It is important that only registered partnership firms are covered under the companies under the section 9. So unregistered partnership firms are not covered. I don't know why they have not been covered, but a large majority of partnerships are still unregistered. So this gives them a leeway to avoid the disclosure under section 90 read with SBO rules. Similarly, there are various pool investment vehicles which are used to invest in the companies like mutual funds or other. So if there is a defined system, a rule which has been provided under the rules to identify. So if there is a pool investment vehicle or entity which are controlled by, if they are members of the Action Task Force, FATF or money laundering, and members of the Security Market Commission, who is a member of international organization, then following individual, a general partner or an investment manager or the chief executive officer who takes the decision making will be defined. So in case of pool investment vehicle, These are general persons who are in the executive capacity that will be disclosed as the SBO in such cases, where the pool investment vehicle is not registered in a country which is a member of, not a member of FATF. Then such entity will, the SBO will be calculated in the manner in which is being calculated for other entities like a company, LLP, partnership, depending on the nature of the structure. Then, as we discussed, that there is a concept of significant influence. So law says power to participate directly, indirectly in the financial and operating policy decisions is treated as significant influence, but that is not controlled. So we need to keep in mind that significant influence does not both different. Significant influence can be said to be younger brother of control, but both are different. Control will include significant influence, but significant influence will not include control. So I've created an example. For example, there is a company X Limited in which the foreign investor holds 40%, and there are 3 subsidiaries. So if I go with a logical route, X Limited, any person who owns majority in X Limited will be treated as a beneficial owner for XX, XY, and XZ. But here the foreign investor who holds 40% shares in X Limited has a right to appoint directors in all these subsidiaries, and his presence is necessary. So by giving the right to appoint director first and then making the presence mandatory, this individual enjoys the right to participate in the financial and operating decisions of this company. So power to participate doesn't mean that there should be a power to have veto, that my consent or assent is mandatory for that decision making. Power to participate, that you have a right to participate. So in case you have similar rights in any company where you are necessary to, your presence is necessary to form a quorum and you have right to appoint a director, then it will be deemed to be a significant influence. Otherwise, 20% is also deemed to be significant influence. But if you would be holding 20%, then you're already meeting the criteria of 10% of equity. So then it doesn't warrant to look into the significant influence. This is only be applicable where there is no holding directly in terms of share. It is an contractual right that you are getting. Similarly, controls, the definition is similar to Companies Act, which is given under the section. But I've taken the same example and just converted it a little more. Now the foreign investor, apart from holding 40%, also have right to appoint directors, right to appoint auditors, right to approve all major decisions. Then, considering the circumstances, situation of control can be involved. Though there are lots of decisions of court cases where positive and negative control has been discussed. So here, accordingly, positive and negative control will be discussed. But if that individual is in some way controlling all the policy decisions, you cannot take any decision with respect to any policy or management without the approval of the foreign investor in this case, then it will be treated as a person who is exercising control. Now, as we discussed, the important thing in case of beneficial interest is the concept of along with. So we have tried to give 2 examples to define how along with can be considered. So here C Limited is the ultimate reporting company and A Limited is the ultimate holding company of C Limited. There are 3 individuals X, Y, Z. All are 33%. So now the onus is on them whether they want to disclose that they are acting alone or not. And if they are not acting alone, how they are saying that if you are not acting alone, what are the your friends or your some known associates, even with other individuals, but you are acting with common intent. You are taking decisions jointly in the board meeting of A Limited. You are investing jointly. All the decisions are taken by you all jointly. There are patterns which signify that all of you always decide in a common framework, or even 2 of them always act together. Then there is a concept of along with. Similarly, in the other example also, there are companies who are holding 33%, and then there are individuals on the top of it who are holding 100% in each of the company. So in all these scenario, while it is always not easy to establish along with, but in cases like where you are, there are immediate relatives, like for example, A, B, and C are husband, wife, and son. I think in such cases, it should be deemed assumption that all are acting together unless and until wife is an estranged wife, or son is a stepson, or he's not working, living along with you, or there are certain disputes which are going along. In such cases, specifically in case of immediate relatives, it should always be deemed that all of three are acting together, and it will be very difficult to establish that all the three are not acting together and they are acting with different intentions of managing the company. So these things needs to be kept in mind while you are determining whether you are acting alone, along, or you are acting independently. I think but you always remain, if you decide that you are acting independently, then the onus will always be on the authorities. If at any point of time they raise a question that you are acting together, so they have to prove that how you are acting together. Then through the concept is also important here. XYZ are similarly holding 33% in the ultimate holding company of A, but XYZ have taken the money to invest in Mr. DD, who is not in the picture, who doesn't hold any shares, doesn't hold any directorships. XYZ acts according to the instructions of Mr. DD. In such case, Mr. DD will be said to be acting through XYZ in limited, and then accordingly a disclosure will trigger. The question is whether Mr. DD wants to disclose this. Logically, legally, there is a requirement, but this is what happening, that persons who are acting through are afraid of disclosing, because here, specifically in cases like this, where there will be a Benami angle also involved, which Ashwani sir will discuss. I've taken a similar example in another case where there is three persons who are taking funds, but they have audited funds. But now in this case, they have entered into a loan agreement, and the loan agreement, and they are giving dividend in lieu of the interest which we are supposed to pay. So in such case, a contrary can be established that the XYZ are actually the owners. Mr. DD is just a financing partner, and he has given funds in view of loan. So because there is a loan agreement which establishes this fact, then it gives a indication then that Mr. DD is not acting through these persons. Then obligations are clear. Ben 1, you have to disclose, then changes in the earlier declaration within 30 days. Key considerations in Form 1. In case select control and significant only when there is an agreement to this exist. Always disclose both direct and indirect holding. In case your declaration is made on account of shareholding, you can also select dividend voting rights, because that accrues with the shareholding. In case you have not made the declaration which was required as on 9th February 2019, there is a question of what would be the date of acquisition of beneficial interest, date of notification of SBO rules, or date of acquisition of rights and entitlement. We have generally taken a view that it should be date of notification of SBO, because the concept of beneficial interest SBO arised on that date. Whether Ben 1 will be required in case of change in direct holding or change in indirect holdings. For example, there is a beneficial declaration of 10%, company allots you 1%. This needs clarity, because there is an issue. While in case of where you are getting disclosure allotment directly, there is you can make the intimation. But what about where your shareholding percentage is being changed on account of allotments to others? Declaration, and then if the declaration is required on every change, if I get 1% now, 1% 6 months later, 1% 3 months later, then every time I have to give a declaration, then it will again create a lot of issues. So this needs clarification from the ministry. Whether declaration is needed in SBO, while the declaration should be required, but the current Ben 1 and Ben 2 doesn't encompasses this situation where you can give a declaration of that you see this to be an SBO. Key consideration in Ben 1 is that whether you need to do a proportionate holding. I've given an example, 51% A holds in B holds in 10. If I do a proportionate holding, 51% of 10% comes 5.1%. Then logically you holding 10% less than 10. The entire 10% if you are holding 51%. Similarly, if X and Y, husband and wife, holding 50-50, how the shares will be calculated? I think in such case also both the shareholders will be filing for same amount of shares that they held in B. They would not be doing any proportionment considering the current state of law. Reporting company, you need to file Ben 2, maintain register. Key consideration, 9 SBOs detail can be filed in one form. Always find separate form for SBOs. Don't file attachment in the form. in case of details of reporting, your furnishing details of reporting holding company, will I disclose? Always take some declaration from them that they are the holding reporting company and attach that to the form. In case of your filing changes in early declaration, ID is required. Disclosure to stock exchange required, similar to Ben 2. But the only thing is, in case you're intimating holding reporting company to this to the ROC, the holding reporting company concept is not there in the stock exchange filing. So I think in that cases, such cases, you have to ascertain the SBO and disclose the details. Obligation on the reporting company. Every company where there are any non-individual member holding 10%, there is a mandatory obligation to send Ben4 for finding the details of SBO. That would be required in all cases every time. In case your member is holding 5%, non-individual member, you allot him 6%, is holding increases to 11%, then also the declaration, you have to send the Ben4. Then in certain these cases where the company believes that there is an SBO or company has the knowledge of SBO, then there is an requirement on the company to send a declaration Ben4 to them to seeking declaration of the SBO. Here the responsibility is only on company when they have very good genuine reasons to believe that there exists an SBO. Lots of the companies are not disclosing their SBOs for various reasons. Action by the Indian authorities, specifically in case of foreign residents or for any reason. First of all, if there is no SBO, always reply to the Ben4 that there is no SBO. In case there exists a SBO, or you're giving disclosure of SBO in other jurisdiction, but you're avoiding a disclosure in India, then the company is under mandatory obligation to take the matter to the NCLT, and NCLT will suspend the rights and may further transfer the shares to IPF. So this is an important consequence, that where there is an SBO and you're not declaring, and company is aware of this fact, the company is under mandatory obligation to move to NCLT to get the rights suspended. Exemptions, these whole lot of entities, if they are holding shares in your company, they are not supposed to disclose any SBO. IPF, government companies, real estate regulated by RBI. While there is no investment vehicle as such regulated by RBI, but I believe NBFCs or CICs, where the only purpose is to do investment, I think they can be treated as a core investment vehicle. Even I think Tata Sons have not given any disclosure on the same basis because they are a CIC. I'll just take a moment to explain holding reporting company. So here B Limited is A Limited holding reporting. A Limited is the holding reporting company, and Y Limited is the ultimate reporting company. In this case, A holds 100% in Y, and Y holds 51% in A and B. So here, because there is an individual who is holding 100% in Y Limited, then the exemption of reporting holding company will not trigger. Similarly, holds 100% is the same manner. I think I am done.
Okay, thank you, Ankit. Thank you for explaining this. Now I will request Ashwini Taneja ji to take up, explain us what is Benami, and then how the Benami is connected with SBO. Whatever Ankit has explained to all of us. So where Benami law will trigger other than SBO? Over to Ashwini ji.
Yes. Pawan sir, thank you very much for giving me this opportunity to share my thoughts on the subject, which is quite close to my heart. In fact, I do not know how I entered into this arena of dealing with the law, dealing with Benami transactions. But since last 2 years, what I have been noticing is now the way our businesses are being done, not only the way our businesses are being done, the way we live is going to be changed because of introduction of this Benami law. You may be thinking I'm exaggerating the things, but I have been closely monitoring how the things are happening. And I will show with the help of some slides that how it has become the lifeline of the business today. The moment you ignore Benami law, you are stuck somewhere. In some countries, it is also called antitrust law. In some countries, they do not know Benami, what Benami law is. But whenever, because I happen to be member of International Association of Tax Judges, so on that platform, I got the opportunity to have discussion on this regard. And when some of the judges were surprised,
Ashwini ji, your voice.
Sir, it seems some internet issue.
Ashwini ji, आपकी voice, yeah. Okay, so what we can do, Sudha, in the meantime, if Ashwini's internet connection is off, I think, so can you just share your experience till the Ashwini will join back?
Sure, definitely, Pawan. Good evening to everyone, and at the outset, my sincere thanks and gratitude to corporate professionals for giving me another opportunity to join this webinar. Let me also put a disclaimer that whatever the views I am expressing, these are all my personal views. Nothing belongs to the organization in which I am employed. In fact, Ankit has very well comprehensively covered within such a short time. He has not left anything for me to cover. However, there are one or two small things, that when I was addressing several webinars or seminars, earlier on this section 90, one question always used to come up is that whether section 89 and section 90 have to be complied with together, or there are two separate sections. People used to think that earlier I have not complied with section 89. Now I comply with section 90, then there will be a problem. Let me clarify that section 89 and section 90 are two different sections and two different compliances are there. The only commonality between these two sections is that under the Companies Amendment Act 2017, the definition of beneficial interest has been introduced under section 89 subsection 10, which is common to both section 89 as well as 90 also. Similarly, though significant beneficial owner is defined under the section 90 as well as in the rules, but who is a beneficial owner is not defined in section 89. What section 89 talks about is that in case the registered owner is not holding the beneficial interest, then in such case, he has to file a declaration with the company that he is the registered owner, but the beneficial interest is held by someone else. The person who is holding the beneficial interest, he too have to file a declaration that he is holding the beneficial interest, but he is not the registered owner. So in this case, what happens is, as per section 89, the person who is the registered owner, but not holding the beneficial interest, he has to file MGT4 with the company. The person who is holding the beneficial interest but not the registered owner, he has to file MGT5 with the company. And the company in turn has to file MGT6 with the ROC within 30 days of that declarations received. Another primary difference between 89 and 90 is that in case of section 89, the company, there is no onus on the company to find out whether you are the registered holder or not. The registered holder is the owner or not. He is holding the beneficial interest or not. The onus is not on the company. Onus is on the registered owner as well as on the beneficial, the person who is holding the beneficial interest. The onus is on them. If they file the declaration, then only the company will come to know, and in turn it will file with the ROC. Otherwise, as far as the company is concerned, it has nothing to do. I think Ashwini ji has come back, and I think he may continue. Then I will subsequently do.
No, Sudhakar, you finish it. Sudhakar, you finish it.
I will take another 3
Please go ahead, Sudhakar.
Yeah, okay. I will take 3 to 5 minutes only, not more than that, because I am only connecting these two sections 89 and 90. So in this case, what happens is the onus is not there on the company as far as section 89 is concerned.
No, Ankit se baat karo na.
But as far as section 90 is concerned, that means identification of significant beneficial owner. The onus is not only on the person who is the SBO who has to declare that he is the significant beneficial owner, but the onus is there on the company also to identify the SBO, who is the person, or the persons who is having knowledge of who is the SBO. In case they are not filing the declarations, he has to issue the notice under Ben 4 to him. He has to make all necessary arrangements to identify the significant beneficial owner. That means if tomorrow, if the regulatory authority comes and the company is not able to find the significant beneficial owner, they have to establish that what are the measures they have taken in identifying the significant beneficial owner. Similarly, in case that Ben 4, despite the fact the notice has been given, If he is not doing it, as Ankit has mentioned it, the company has to approach the NCLT and get the restrictions imposed as far as those concerned shares are concerned. So according to me, of course, Mr. Ashwin sir is the expert in this case, he will do it. According to me, section 90 is concerned, it is nothing much concerned with Benami. But as far as section 89 is concerned, the person who is holding the beneficial interest, if he is not filing the declaration, there it amounts to a benefit, that Benami holding, and that Benami holding, whatever the law is there, that gets triggered. And the primary intention of section 90 is to remove the opaqueness, whereas section 89 is concerned, it is not the intention that to remove the opaqueness as such and all. I think this is the primary thing, but the rest of the things, okay, that beautifully Ankit has covered it. There are some gray areas are there, like he has already mentioned about it. The primary thing what ministry has to give the clarification was that what is the change in the significant beneficial owner. In fact, that you might be remembering that primarily the SBO rules have come, which came into force on 13th June 2018. In fact, Institute has given representation to MCA because those rules were virtually not possible to implement. And ministry was kindly accepted 90% of the recommendations of ICSI, because I was also one of the persons who met the MCA officials at that point of time. So I have some kind of information. But the remaining 10%, one thing was that the change in the SBO means what? Suppose if I am the SBO, there is a change in me, whether I have to file the declaration, or my shareholding, which I have declared initially, is going up or down, whether that also amounts to change in the SBO. I mean, SBO holding, that clarity is not there. I think, Pawan, with this, I will hand over back to you, and in case of any questions are there, I will take up.
Okay, thank you, Sudhakar. Thanks for giving the difference between 89 and 90. Now I'll request to Ashwini to continue.
Yes, so as I was saying, actually, Sudhakar has, set the tone very right, and I will pick up from there. Sudhakar sir was saying that it is just to remove the opaqueness. All right, we agree, it is there to remove the opaqueness. But while removing the opaqueness, if I become transparent, can I still be held to be violating some other law? Okay, I am complying with section 90, but in that process, if I come clean, am I granted a protection that, okay, even if you have violated some provisions of PBPT Act, but you will not be covered because you have made the requisite disclosures under section 90. Is it so? If it is so, all right. But if it is not so, my dear friends, please beware of that the situation which we are going to face, कि हम कुएं से निकलेंगे और खाई में गिरेंगे जाकर. So to avoid a smaller problem, we might be embracing a larger problem. So that is why it is essential to know what exactly Benami law is. What we perceive it is that, or it is something more than that. So for that, I will request for allowing share screen so that I can show some of the slides very quickly. All right, here we go. And Ankit, I will be sharing my slides.
Sir, if you want, you want to share the same slides that you shared with me?
Yes.
So should let me share those.
It's opening one slide. Is it visible?
No, it's not visible. I think, sir, you have to again stop screen and then.
No, you can stop share from your side. Let me do
Yeah,
I want to. No, you have to stop share.
Ankit, you stop sharing. Ashwini is sharing.
Sir, I have not utilized the sharing screen. It's being used by Ashwini sir only.
Ashwini, now you can share. The screen is yours.
Okay. All right. Is it visible now?
No.
Is it visible now? Am I audible?
You are audible, but your slides is not.
Can you hear me?
Yes, we can hear you. Yeah, now, yeah.
I don't know then what is the.
Yes, now it is visible. Your slide is visible.
I have to share screen. Now I will share.
Sir, last time it was visible.
Now, is it okay now?
It's visible. Now you can, yeah. Just go for slide share.
Yes.
Yeah.
So, yes. So kindly see section 1.3. Now this is very essential. Section 1.3 has been, put on the statute in such a manner that as if the old transaction will also be covered. So first thing first. So some people are asking whether this law will be retrospective or will be prospective. Though this law has been enacted with effect from 1/11/2016, but this issue is pending with Honorable Supreme Court. So far, every authority is saying, all Benami law officers are saying this is retrospective. So meaning thereby even the transactions done prior to 1/11/2016 shall also be covered therein. Therefore, we need to be very, very careful about it. Then what is the definition of Benami transaction? Very essential to know for all of us. It says a transaction or arrangement where a property is transferred to or is held by a person and the consideration for such property has been provided or paid by another person, and the property is held for the immediate or future benefit, direct or indirect, of the person who has provided the consideration, except when. Though these are some exceptions, we will deal little later. So this definition clause suggests two things to happen simultaneously. Property is held by a person, but consideration paid by somebody else. Number one. Number two, the beneficial use is done by that someone else for whose benefit the property is being. So in a way, this law comes into picture, or the provisions of this law are triggered when there is some kind of duality. Duality means, in fact, there should be singular ownership. So the legal owner and the beneficial owner should be remain ideally. But when it is bifurcated into two parts, meaning thereby the legal owner becomes somebody else and the beneficial owner remains somebody else, then there comes duality. And whenever the duality comes, Benami transaction is triggered. It can be categorized within the meaning of the definition of the term Benami transaction. Number one. Number two, there are some other clauses also. This is such a quite sweeping and exhaustive definition that any possible situation of life can be covered herein. For example, I have taken three more clauses: a transaction arrangement in respect of property carried out or made in a fictitious name. C, a transaction or arrangement in respect of a property where the owner of the property is not aware of the denies or of knowledge of such ownership. D, a transaction or arrangement in respect of a property where the person providing the consideration is not traceable or is fictitious. So, there are these four parts. Then if you kindly see, exception is given only here. Only these 5 exceptions are there. So for relevant for us would be exception number 2. Property held by a person standing in fiduciary capacity for the benefit of another person and includes trustee, executor, partners, director of a company or depository under the Depository Act, and another person as may be notified by the central government for this purpose. So though the definition is inclusive, so if you will see, property held by a person standing in fiduciary capacity for the benefit of another person and includes, so definition is inclusive, includes trustee, executor, partner, directors of a company. So meaning thereby it includes this, or it can include anything else also which is in the fiduciary capacity. So in this entire law, with regard to the transactions done by the company or with the company, if something is a saving, clause or saving scope, which is this clause with regard to fiduciary capacity. I am saying this also for the reason that out of Indian Trust Act 1882, section 81, section 82, 84, 94, all have been removed. Only section 88 has been retained, which talks about fiduciary capacity, advantages gained by fiduciary. Say, for example, where a trustee, executor, partner, agent, director of a company, legal advisor, or another person bound in a fiduciary character to protect the interest of another person by availing himself of his character, gains for himself any pecuniary advantage, then they said it must hold the property on behalf of the other person, advantage so gained. In other words, earlier Benami transactions were allowed because of Indian Trust Act, these 3-4 provisions which I mentioned. So they repealed all those provisions in 1988. But even after revealing all those provisions, they are still continuing to with this section 88. So if anything is saving raised, that is section 88 of the Indian Trust Act only. And this judgment particularly of P.V. Sankara Group, Supreme Court judgment 1994, which also talks about if the consideration for the purchase as well as the improvements of the property were met with the funds of the respondent for whom the petitioner was acting as an agent and power attorney, he thereby obviously had acted in a fiduciary capacity as agent. So if it is acting in fiduciary capacity, then this exception will come into picture, this exception which I mentioned in clause number 2. Otherwise, my dear friends, everything mentioned in A, B, C, D, if anything falls in any of these categories, it is Benami. With good intention, without good intention, the legislature has not made any difference therein. Since the legislature has not made any difference therein, we cannot keep any such thing, I mean, as a matter of argument. So kindly see, definition of property is also quite wide. You must all read the definition of property. It means asset of any kind, whether tangible, immovable, intangible, corporeal, incorporeal, any right or interest in legal documents or instrument, evidencing title to or interest in the property, and where the property is capable of conversion into some other form, then the property in the converted form and includes the proceeds from the property also. So if property is once Benami, that in always it remains Benami, even if it is transferred, because then its proceeds will become Benami. So that harsh the law is. And then I will read 2 more definitions, and thereafter I can come back to this SBO part. Benamidar means a person or a fictitious person, as the case may be, in whose name the Benami property is transferred or held, and includes a person who lends his name. Then beneficial owner, it means a person, whether his identity is known or not, for whose benefit the Benami property is held by Benamidar. So beneficial owner here is having this meaning, which is quite different from the meaning which we understand in common parlance. So friends, this is all about the understanding of the law with regard to the basic fundamentals with regard to the Benami transactions. Now let me come back and explain with regard to the SBO concept. Before that, I will also share another slide which I made specially designed for you for today. Share screen once again. Where is that? This one. Yes. So share screen, and I will be this and this. Yes, these slides are visible.
It's visible,
I
sir.
hope
It's visible.
All right. All right. Thank you. Yes. So this slide I have made specially for you for this purpose. Kindly see. I mean, now there is going to, somebody may ask, sir, where is now Companies Act is different, Benami law is different, we are making compliance here. No, sir, the things are going to be changed now. There is going to be a strong interplay between all the laws dealing with economic offenses. Now you see these chimpanzees were attached by the Enforcement Directorate because of violation under Wildlife Protection Act. Then this distillery was attached because of it discharged more water into river by the PMLA department. Then in the recent news, you must have seen, then Modi's Benami law sends companies for cover. Companies running for cover because many listed companies have been hit, which was not the objective when this law was brought out. I mean, to my knowledge, there are many companies, I mean, from Mumbai and elsewhere, where even listed companies have been hit. Infrastructure building companies have been hit because they created land bank through other companies. So those companies which has been created for creating land bank, buying land elsewhere, they have been treated as Benami companies, and the entire land as Benami, and they have been attached. Then CB EDI action may now follow IT default probes because multi-agency scrutiny is going to take place, and you must have read this SEBI signs MOU with CBDT. You must have definitely read this memorandum press release, which was issued on July 8, 2020. And you see monitoring agency for Benami law is also CBDT. So they have got entered into an exchange of information kind of concept. You can read it, it is on the slide. So after these kinds of things coming up, I mean, whatever is there which is prone to be hit under Benami law, information of the same will reach very fast through SEBI and through other mechanisms. Yesterday, portal has also been launched by the Income Tax Department, where one can file complaint about any Benami property, any tax evasion, etc., etc. So therefore, we have to be careful. Then friends, I have made this slide to show that there is going to be a strong interplay between these laws. And if you kindly see, I have put this Benami law on the center of the same as a central figure, because whatever violations will be done in the economy now by anybody, now it will assume of a significance of the central position, because the violation will be done using pseudonyms, by creating another structure, by in other names, by creating a facade, etc., etc. And if any of these things happens, violation of Benami law will simultaneously take place. And section 6 of Benami law says that this law is in addition to the provisions contained in any other law, and not a subjugation of any other law. Meaning thereby what they are trying to say, board has given the SOP also, board means the Central Board of Direct Taxes has given an SOP also, that in these circumstances, parallel application of other laws is also possible. For example, somebody makes tax evasion, then he will be held up for tax evasion under income tax law, he can be held up for Benami law also. Similarly, somebody is done money laundering, he can simultaneously be held up for Benami law also. Similarly, somebody is doing violation under Companies Act or SEBI regulation, he can be simultaneously held up for Benami law also. Now, this is one example which I would like to skip for the time being, that where a person, how by doing one illegal activity, he is giving violation of many laws at one point of time itself. Then this concept which I picked up from definition, I mean, just for the sake of clarity, I am reproducing this slide, that the concept is there before you. In Benami law, there are two parties involved and plus the seller, meaning thereby, suppose seller wants to sell the property to, suppose this beneficial A wanted to buy the property from B, but instead of getting the property registered in A's name, the property is being transferred in C's name, and the consideration is paid by A to B directly or through C in any manner. Consideration is being paid or provided. If you would have noticed the definition, it says paid or provided. So consideration is paid or provided by A, property is being registered in the name of C, beneficial use or the rights of ownership will be enjoyed by A. If it happens, it becomes Benami. Then this I have tabulated, I mean, just for the sake of simplification, that part A, B, C, D, there are 4 parts in the definition. Now, if you kindly see, there is only exception which is relevant to us for the time being is person acting in fiduciary capacity. If the case does not fall in this exception, then if these parameters of clause A or B or C or D are fulfilled, it will be Benami. This law does not provide any scope wherever a person may say that I did not make any tax evasion, I did not make any other violation of any other law, so therefore kindly do not treat my transaction as Benami. No, if transaction is Benami, consequences will follow. And what are the consequences? The property is liable to be attached immediately, forthwith, under section 24(3), and finally under section 24, and finally to be confiscated under section 27 of PBPT Act. That is number 1 consequence, which immediately happens. Then fine up to 25%, payable by whom? By 3 parties. Number 1, Benamidar, number 2, beneficial owner, and number 3, the person who has advised them or who has helped them to doing these transactions. 25% each of the market value of transaction. Then this is not enough. Then imprisonment up to 7 years if it is proved that the Benami transaction was done. For whom? For all these 3 persons. So any person advising them, it could be company secretary, lawyer, chartered accountant, any professional, non-professional, their relative, anybody. If he is found to be involved in assisting in doing Benami transaction, I mean, he is also liable for fine and punishment both. Then interplay with Income Tax Act. Probably this is not the topic for today. I would be skipping it here. Then this I would like to discuss with you, how the international structures can also be roped in under Benami law before I directly come to SBO. Now, I have given this example because this is covered by a direct judgment of AAR, Authority of Advanced Ruling. There was one US-based company. It wanted to make investment in Indian company. Now, instead of coming directly, it wanted to probably take the benefit of tax treaty benefit, that is DTAA benefit. So therefore, it routed its investment, say, through Mauritius. So say company U company makes investment in M company, and M company in turns make investment in I company, Indian company. Now, in the income tax proceedings denied the benefit of treaty benefit on the ground that this M company is just nullity, just dummy of U company. Actual company is U company only, and which is invested in I company. So we will not grant this treaty benefit. So GAR was invoked. So if GAR was invoked for this reason, now that is whether that will be end of the story. Something else can also happen. Here something more can happen, and the something more is that it can be treated as Benami also. Now somebody may ask, sir, Benami transactions are applicable domestically only, not on international. Yes, not on international assets, but it can be invoked on international transaction if the underlying asset is located in India. So here the M company, so U company has invested in Indian company through Mauritius route. So investment in India, shares are held in India. So shares held in Indian company can be treated as Benami shares of U company. So U company can be treated as beneficial owner, N company as Benamidar. None of them can be prosecuted because they are not in India, but the property being located in India, it can be attached. So, I mean, that much harsh this law is, friends. Now, coming back to this significant beneficial ownership concept under Companies Act. Very well explained by Ankit ji that in what manner, how a person will be held to be a significant beneficial owner and how he will be liable to make reporting. Now, the issue before us is, prime issue before us is that under what circumstances a person, if he does any reporting, candidly saying that I am the beneficial owner, under what circumstances he can be hit under the provisions of Benami law, that is PBPT Act 1988, that is Prohibition of Benami Property Transactions Act 1988, as amended with effect on 1/11/2016. Now, friends, on this topic, lot of debate can be done, but to give my thoughts, in a very simplified form, I will say wherever a person can be said to be beneficial owner by way of a legal arrangement, meaning thereby he is legal owner also and then he enjoys the beneficial rights, then I think he will not be hit under Benami law. What do we mean by it? Suppose a person A is holding shares in A Limited is holding shares in B Limited is holding shares, say, in the reporting entity. No problem. Because A is legal owner of the ultimate holding company, not only any legal or indirect or any discrete owner kind of person. So long as a person can claim his ownership or rights therein based upon the legal channel, there is no problem. But if the link is broken, then there comes the problem. And where we can say that link is broken, probably that can be said to have been broken where it is said that the person is acting through. Because in acting through only the link is broken. As far as a person is acting with, I think acting together, I think there is no problem, much problem. Because if 4 persons are joining hands and becoming beneficial owner, there may be some problem in some other laws. Maybe SEBI law, maybe Companies Act somewhere. But as far as PBPT Act is concerned, it has no problem. But if the problem arises that, suppose Mr. A, there is Mr. A, B, and C. Now, all these 3 persons have invested in A Limited, say, right? But the investment made by B and C are not their own investment. Suppose Mr. A gives amount of money to Mr. B and Mr. C and requests them to make investment in A Limited so that A can exercise control through B and C. Then B is exercising control, but not in a legalized manner, because A has funded them so that it could acquire the ownership rights. So here comes the problem. A is acting through B and C, and that is how he is controlling the majority stake, and that is how he controls the ultimate reporting entity. In that scenario, friends, there is going to be. Now, Sudhakar sir will ask a question definitely. Mr. Taneja, tell me, I mean, A can fund the money to B and C also? Yes, very right, sir. It can fund the money to B and C also. But the problem in that scenario would be that B and C will have to show it was purely a financing arrangement. An arrangement whereby B is liable to repay the money on interest or in some other admissible terms, and C is also. So A is not having any ownership rights over the shares which have been purchased by B or C. So meaning thereby, जो जैसा है अगर आप वैसा दिखाओगे कोई बेनामी लॉ नहीं है, जो जैसा है वैसा नहीं दिखाओगे, कुछ और दिखेगा तो बेनामी लॉ आ जाएगा। और जो जैसा नहीं है वैसा आपने बैन 1, बैन 2, बैन 3, बैन 4 या किसी भी माध्यम से दिखा दिया, हो सकता है कि आप बेनामी सेक्शन 90 की कंप्लायंस कर दें, बट स्ट्रेट अवे यू विल बी इनवाइटिंग टू योर डोर्स द PBPT ऑफिसर्स whom we call as initiating officer under the law. That is the part of Benami Prohibition Unit of Income Tax Department. So that's all, friends. I wanted to mention. To share with you, but few more 2-3 examples which I will quote quickly so that you can further understand the concept, how the things are working. Now, this slide which I opened before you. Now, Mr. N means NRI, who went from India abroad, and he wanted to buy land in India. He was probably not allowed to buy land in India. He makes contact visit with his foreign friend, Indian friend. Look, I have to make investment in India, but I am not able to do that. Okay, I am sending you the money, so you buy land. Now he can give land money to Indian friend. Indian friend can become owner, no problem. But when the proceedings were going on under income tax or under some other investigation by SEBI and all that, Indian friend got afraid and he simply admitted कि no sir, मेरा कुछ नहीं है, ये तो सब जो मेरे दोस्त वहां बैठे हैं साहब बाहर, उन्होंने पैसे दिए थे, कहा था आप लैंड ले लो, मैंने ले ली साहब, मेरा कुछ नहीं है. Now this land was immediately attached. This case is from Baroda. Land was immediately attached. That land which he bought in his own name, and the notice has been issued to both the persons, because he was also beneficial owner, was also, that is the person sitting abroad, he has been treated as beneficial owner, person sitting in India has been treated as benamidar, and notices have been issued to both. Indian friend can easily be prosecuted, but that NRI friend, whenever he comes back to India, he may be liable for prosecution apart from land going to the government. So 25% fine and then prosecution, etc. Every preparation is done unless they are able to prove that no, it was not like that, there have been some wrong statements, etc., etc. So money laundering is not the topic today. I think I can stop sharing now so that I can hand over the mic back to Pawanji if you want to take question answer session.
Okay.
Or if you want 2-3 more examples to be quoted, I can take up that whenever you will permit.
Okay, thank you, Ashniji. I think you have given the overview of the Benami law and how this is connected to SBO. The most important explanation which you have mentioned, the difference which is confusing with or through. So you have very nicely and very lucidly presented this, that what is the meaning of with and what is the meaning of through. Through is the risky, with can be risky in some law, but not in the Benami law.
Yes.
And the most important thing which you, Ashwin, Ankit and Sudhakar has said, that is one clear message: transparency. What you are, show the same way, then it is not a problem in SBO also, not a problem in Benami law, any other law. But if you are showing something differently what you are, then you are in trouble. Thank you very much for explaining this very interestingly. Now coming to the question answer session, I have received various questions. So what I'm doing, I'm taking first questions which I have received just now, because some questions are very interesting questions. So I'm covering up. Now, first question is, what is, Ankit, I think Sudhakar, you can tell, what is the difference between registered owner and beneficiary owner?
Yeah. So Pawan, this was exactly what I have mentioned, that beneficial owner as such is not defined in the Companies Act at all. What Companies Act has defined is only the significant beneficial owner.
Okay.
Now, significant beneficial owner is different to that of beneficial owner. Beneficial owner is, in a loose parlance, what we can say is, in the common language, the person who got the beneficial interest, he is the beneficial owner. Wherein actually the registered owner, if he is different to that of beneficial owner, then section 89 gets triggered. That is what exactly I was mentioning. The person who is registered, he may be an ostensible owner. That means he is not the real owner. For that, what happens is that the declarations are to be given both by the registered owner and the person who is holding the beneficial interest. If the declaration is filed, then there is no question of any, the transparency is there, the opaqueness is not there. That's why there is absolutely no issue. But in case that 89 declarations are not filed, then definitely, according to me, Benami law gets triggered, because there the person's identification is the person who has given the funds is somebody different, in whose name the property, I mean the shares got registered is different, and the person who is holding the beneficial interest is not coming openly. That's why definitely that Benami law gets triggered there. Number two, as I was mentioning, that several company secretaries and chartered accountants got a confusion that earlier, because for whatever the reasons it is, I have not filed that 187C declarations. Now in the present 89 declarations, if I file 90 declaration, those things will get opened up. No, it is not so. 90 is entirely different. 89 is entirely different. That's what my viewpoint.
Okay. So Ankit, the same thing. What is the difference between 89 and 90?
I think, sir, this is what Mr. Sudhakar just outlined, the difference in section 89 and 18 in terms of beneficial owner and beneficial interest.
Okay. Actually, sir, what is the difference between the definition of SBO in Companies Act and Benami Property transaction?
Look, as I said, that here the beneficial owner is clearly defined under section 2(12), which says a person who has paid the money and who is exercising the beneficial ownership rights. So meaning thereby he is the true owner behind the scene. So anybody acting as an owner but not with title is beneficial owner. Number one. Number two, now this one interesting question I saw on the question answer section, and this is a question of the country. And I really urge to our honorable government that they should look into this aspect. In all the countries, there is some arrangement of settlement, some compounding, whether Benami law offers this thing. So the question which has been asked is, suppose, sir, a person says, okay, I have paid the consideration, I have not declared myself the owner, now I am declaring myself the owner, whether he will be permitted. Very strangely, Benami law says no U-turn is allowed under this law. Meaning thereby, if Benami transactions are done, the consequences are inevitable. All the three consequences: attachment, fine, and prosecution, and which will be evident from reading of section 6(1), which I can quickly read before you. Slide is there. Can you see that slide? This section 6(1).
Yes, it is visible.
Which says the Benamidar shall not retransfer the Benami property as held by him to the beneficial owner or any other person, and if it is done so, such transaction shall be deemed to be null and void. Now the authorities are deciphering its meaning by saying that कि sir, अगर आपने एक बार बेनामी ट्रांजेक्शन कर लिया, यानी कि once you have done it and you admitted that you are beneficial owner, then this property becomes property of the government. You cannot undo it. No U-turn is allowed. No, you cannot even make any payment, etc. Nothing. Then kindly see section 57 also. Any transfer made after the issuance of notice under section 24 shall be ignored, notwithstanding the provisions of TP Act 1882. So that harsh the law is. So therefore, friends, this situation is absolutely different here. Thank you.
Okay. Sudhakar, how we can say that two individuals are acting together for the purpose of SBO?
See that when two individuals are acting together, definition is clearly given in the rules, SBO rules. Now it is up to the individuals to come to declare that yes, we both are acting together. They may be relatives, they may not be relatives also. However, per se, the relatives are acting together, that also is not correct. Sometimes it may so happen that my daughter who is there, who is my relative, she might have got married and she is not doing on her own and I am doing on my own. So acting together, there should be a common intent and common purpose towards which they are acting together. Then only that it is there. So if both these people are declaring themselves that we are acting together and we are the SBOs, absolutely there is no issue. Suppose if we say that despite the fact we are relatives and we are not acting together, then the onus depends upon the regulatory authority sometimes to establish that how they are saying that we are acting together. But depending upon the documentary evidence, depending upon the transactions, the decisions it is taken, it is not that difficult for the regulatory authorities to prove that we are acting together.
Okay. Ankit, what is the consequence for non-disclosure of SBO?
This section provides the penal provision of punishment that will be required, and in case the company believes that there is an SBO or the information is wrong, then the company also will require to file this application before the NCLT for the necessary action.
Sudhakar,
Yeah.
is there any individual has SBO and does not disclose the company how to get the information?
See, as I was mentioning to you that it is actually primary responsibility to identify the SBO is of the company secretary, because he got the custody, he is the custodian of the register of members. So he knows that people who are holding more than 10% shareholding. He cannot per se just see the folios and then decide it. Sometimes it may so happen that, say for example, that there are about 10 people having the same residential address, and he can presume that they are all acting together. In such cases, what happens is he has to give a notice to them if they are not declaring themselves as significant beneficial owners in Ben 1. He has to give a notice to them that in Ben 4, that as per my ROM, you deemed to seems to be the SBOs. You have not filed the declaration. You please give me your explanation. If they give the explanation, if he is satisfied with their answer, then he don't need to worry. If they are not given the answer, or if they are given a very evasive answer, he is not satisfied with the answer, that point of time, definitely he has to approach the NCLT, get the restrictions imposed on those shares. And of course, that whatever the penal consequences are there, they will follow that.
Okay. Ankit, if there is any reduction in shareholding of the member which has subsequently reduced the ownership of SBO, do you need to file Form 2 with the ROC?
Sir, am I audible?
Yeah.
So, as per the current provision, it seems that when there is a change, it needs to be filed. But in case it goes beyond the SBO limit of 10%, I don't think that in that case it will be required as of now.
Okay. Ankit, your voice is just corrected. Some problem is there. Correct. Okay.
Or I will just add what the question you have asked Ankit. In fact, you see what happened. This is where the question comes that change in the significant beneficial owner means what? It is the change in the complete person altogether, or change in his shareholding also. That clarity is not there. So this is what Ankit is also trying to mention, that say for example, I am holding today 11%, and tomorrow it is becoming say 15%, or it is coming down to say 10.01%. Whether I need to file the declaration, the clarity is not there. In fact, at one point of time when I was discussing with the ministry, that point of time, what they asked me was, what is your view? I said, the moment the opaqueness is removed, whether my shareholding is 10% or 20%, how does it matter? But the answer is not there as on date. Maybe by abundant caution, if there is any significant change in the shareholding also, advisable to file.
Okay. Actually, sir, there are so many questions on SBO, just I'm covering, then I will come to you. So because time is, we have crossed the time. So I'm just for 15 minutes, I'm extending so I can give all answers. So be specific and we can close all the questions. Ankit, if the reduction in beneficiary ownership occurred 3 times in a financial year, will each time we have to report individually?
This is what we just discussed. That this is not clear as a matter of caution. If so far it is not going beyond 10% and there is a decrease, you should be filing. But this needs clarity from the regulator.
Okay. Okay. Sudhakar, what do you mean by what change in use in Rule 3.2 of SBO rules? Does that imply if an SBO acquires even 1 share, he is required to give Ben 1? That is not clear.
See, the answer is the same, Pawan, that it is not clear. But only thing what I say is that the register in which you are making the entry, that point of time you have to also register that how many number of shares he is holding. And when you are filing with the ROC also, you have to file that. And these documents are open for public inspection. So it is better that whenever there is a change in the shareholding also to file those specific returns. But now the question comes, even if 1 share going up or down, though it looks a bit awkward to file like that, but if you answer, the theoretical answer for that is, yes, you may have to file it.
Okay. Ankit, now 2 questions connected this. If change restricted,
Watching on my audio, if you could just put it to Mr. Sudhakar.
Okay. Sudhakar, button is on you. Is the change restricted to only in the identity of SBO irrespective of percentage change?
Yeah, see, suppose if that percentage from 10%, if it is coming down to 9%, no more, I'm no more a significant beneficial owner. That is definitely amounts to a change in the SBO. So I have to file that Ben 1 definitely in such case. That is very clear. Similarly, today I might be holding say 9.9% and tomorrow my shareholding is going to 10.01%. I becomes SBO there. So I have to file Ben 1 with the company concerned.
No, but if the company's holding is in, Sudhakar, company's holding is increasing because the overall holding has this number of shares you are holding 11%. Company's increasing its capital, so your holding has become 9%.
Yeah, what you are trying to say is because of the corporate action. Because of the corporate action, my shareholding is getting affected.
Yeah.
Whether it may be reduction of share capital or it may be increase of share capital wherein I am not subscribing, my shareholding may change. Yes, that point of time, as I was mentioning that the clarity is not there, still advisable to file it. Now the question comes, how I will come to know my shareholding is changed or not? Definitely you are getting a demat, this thing with you, and the company is filing the shareholding pattern from time to time with this thing. As soon as you come to know about that change in your shareholding, you have to file that.
Okay, Ankit, your voice is clear. Just check.
Sir, let me try.
Yeah.
It is very clear.
Okay, now very clear. More than better than earlier. Okay, but
using some Benami audio, I think.
you were using some. Ankit, is family member deemed to be acting together?
Sir, I think Sudhakar ji mentioned in the first answer itself that generally it should be deemed together. But in case, like I said, mentioned, in case of estranged wife, estranged brother, it will be a different view can be taken that the families are not acting. It is always on the regulator to explain.
Okay, Sudhakar, if the company already filed MGT 4, 5, 6 under section 89, is it still required to file Ben form?
Yes, as I mentioned to you very clearly that I want to clarify to everybody, section 89 compliances are different, section 90 compliances are different. The only connection between these two sections is nothing but definition of beneficial interest. Otherwise, there are two different sections.
Sir, but I think there is one problem. This rule says that if you have filed a declaration under 89, it will be deemed to be your direct holding.
That
so
is
when
different.
it becomes
that is only an exception. Ankit, I do appreciate that explanation 2 says that where you file the declaration, that point of time, you don't need to file SBO, no doubt about it. Okay. But if you are not filed a declaration there, yes, it amounts to as if it is an indirect holding. You will be responsible under 90.
In this current question, they have filed the declaration under 89.
Correct.
Okay, actually, sir, if I give disclosure of SBO under Companies Act, will it suffice to Benami Property Transaction Act, or I have to do something?
देखो, मैं वैसे इस क्वेश्चन का आंसर दे चुका हूं, पर ये बार-बार पूछा जाएगा। 4 बार भी पूछोगे तो मैं वही जवाब दूंगा घुमा के। अब मैं दूसरी तरह से देता हूं जवाब। तो सुधाकर सर ने एक बड़ा अच्छा रूल दिया, and the rule number 1 is there should not be opaqueness, right? It means there should be transparency, but that is rule number 1 only. Now rule number 2 is there should not be anything illegal also. So after removing opaqueness, what is left out is transparently legal, not transparently illegal. In other words, if I am doing everything transparently in my life, I cannot be allowed to do illegal things, even if I do them transparently. That is how I would sum up.
Okay, so I have to see first transparency.
No, I have to see first legality. Whether
legality, correct. In fact, Pawan, I would like to just add one more minute I will take. In my, whenever I was addressing the conference, I used to say that in the good olden days, we used to see the villain wearing a hat and having a cigar, and he was in the darkness. He used to give the instructions. And that other followers and all, they used to follow it. Only at the end of the movie, we used to come to know who is the person behind the curtain. The person who is smoking the cigar and wearing the hat. Normally that Shetty and other people used to be there like that in those days. Section 90, if anybody wants to understand, the person who is behind the screen, who is in the darkness, the intention of the government is to bring him into the light. That is what the thing is.
All the movies or old movie, if we bring it here today, they will lose suspense.
Yes. So, in other words, I mean, this SBO is not granting any immunity.
Correct. Absolutely.
Just compelling you to unveil yourself.
Okay.
That's all.
In fact, Ashwini sir has very beautifully brought it. Opaqueness removal is not sufficient. Opaqueness is to be removed in a legal way.
Yes.
I really hats off to you, sir. Very big, very beautifully you brought it.
And sir, And now, for example, the purpose, we should understand the purpose also. Now, this is a global phenomena, and there are many reasons. Now, for example, this platform which Zoom is using, nobody knows whose owner is. So unless it is declared, the ultimate beneficial owner is not some US company. It is beneficial owner is somebody who is crony of Mr. Xi Jinping, somebody XYZ. So, I mean, somebody would ask, why? Then what would you do with this information? That is for the supreme wisdom of the government, what is to be done with this information. But at least they should have correct information so that they can take a correct decision in the interest of the country. That's
okay, Ankit, we have issued CCPS and we know the exact diluted figure of such CCPS. So initially we shall be filing band 2, but on conversion, do we need to again file the form as there is a change in class of security? So if the change of class of security, should I file the band 2?
But if you have filed initially and the overall percentage remains the same, even at the time of conversion, then you need not to be filing any further declaration.
Security will change.
Yeah, security will change, but the overall percentage ownership remains the same.
But there is a possibility overall percentage may also change.
So then the question will again come of the change, or that for how much change you need to inform.
Okay. So Mr. X is holding 2%, his wife is holding 8%, his son is holding 1% in listed company. Is SBO disclosure required? Because 3, they are less than 10, but collectively they are more than 10.
You see, I will answer this question in a slightly different way, because these percentages and all, as you were mentioning initially, you yourself was mentioning, very difficult to register and give the answer. One thing I can say that if the father is holding 8%, son is holding 2%, wife is holding 1%, collectively they're holding more than 10%. Okay, so here individual acting alone or together with, it is there. That's why what happens is, if these 3 people are acting together, definitely they will become SBOs. Now what happens, whether all 3 become SBOs, the person who is 8%, it is the person who is controlling the company, he will be the SBO. So those 3 can declare themselves as SBOs, or they can say that the person who is holding 8% is SBO. Let me also clarify one more thing. A person without holding any shares, still he can control the company, still he can exercise significant influence. He will be the SBO. A company can have more than one SBO also. A company may not have any SBO also. Let me put it very clearly that a reporting company is not mandatory to have an SBO. It may not have an SBO. It can have more than one SBO. An individual without holding shares, he can become an SBO.
Okay. Ankit, if combined together, there will be SBO, but Mr. X says that his wife is financially independent and she is not a PSE. How will you identify SBO in this case?
Then the call will be taken by the owners themselves, that they want to determine that they are acting in concert, and then there will not be any SBO declaration that will be required. Then it will be up to the authorities to establish that these are acting together.
Okay, Ankit, one more thing. If a foreign company holds 51% and husband wife is the owner of the foreign company, will they require to give?
Yes, it is. All foreign companies are covered. If they are the ultimate holding company of the Indian company, then the similar disclosure will be required by the persons who are holding majority control in that company.
Okay. Actually, why this is one question. Please define Benami property and how can we establish on it?
Sir, Benami property, I had defined any damn thing existing on earth which you can see, touch, feel is property. That I read the definition quite exhaustive. So wildest and widest possible definition of property has been given in Benami property. So any rights, instruments, as I read. So therefore, I mean, rights will also be covered. But when I was listening to you, one thing came to my mind. Suppose the relatives are involved. So relatives may not fall, even if they're acting through, may not be hit by Benami law because of some exceptions given. So because husband can, act through his wife. So if your husband buys a property in the wife's name, that is not Benami, provided it is his own wife. Because somebody asked me this question also, okay, sir, whose wife? So it should be his own wife, not any Benami wife. So if a husband is, Benami law under, sir, funny questions are coming because everybody is having different kind of tensions. Somebody is having this tension, my Benami property should not be detected. Somebody is having this tension, my Benami rishta should not be detected. So as the tension comes, so comes the questions. So then I told him, no, it should be your own wife. If you buy property in your own wife's name, provided it is from known sources, explained sources, then you can buy in this. But if you want to buy in, say, brother's name, sister's name, father's name, mother's name, then you have to be joint owner. Then they cannot be exclusive owner Benami. You have to be joint owner with them. So to that extent, only saving grace is there.
Okay. So
In fact, Pawan, let me add one thing. The section 18(9), when we were talking about the S12 section of that under Companies Act 1956 is 187C. And when 187C was introduced, one of the objectives of that 187C was to deal with the Benami holdings. That's why the amount of importance what we give to section 90, we have to give to section 89 also. If section 89 declarations are not filed, according to me, getting that Benami Transaction Act trigger is more than of section 90.
Okay. Okay.
So I would rather in this manner, what Sudhakarji is saying, I will take it forward. In fact, this Ben 1, Ben 2, Ben 3, or Ben 4, this is not any license kind of immunity. Rather, this is a fishing net for the wrong fish.
Correct. Absolutely.
One should understand it clearly.
Okay, Ankit. Now, actually, if all three speakers, because I think majority people are waiting, so we can finish question. If you have, if you allow me to, I can just try to finish questions.
Yes, sir, please.
Okay. Now, is there any requirement to obtain SBO declaration from the shareholders on annual basis or only when there is a change? Ankit.
So there is no requirement of annual basis. As and when you become the SBO, then only it is required.
Okay. Sudhakar, LLP is a shareholder in private company, say private limited, 69%. LLP now converted to private limited company. Whether private limited again required to file form Ben 2 due to change in constitution of LLP to private company?
See, unfortunately, that clarity is not, the LLPs are not covered. If LLP is a shareholder in the reporting company, unlike partnership, LLP is not covered there. They said that only partnership registered under the Partnership Act. So that's why the way Ankit has mentioned, unregistered firm can take the leeway, even LLPs can also take it. The moment they got converted into a company, yes, the company is a body corporate, it is holding in the reporting company more than 10%.
LLP will come in body corporate?
No, LLP will not come in a body. See, LLP, as far as the rules are concerned, it is not a body corporate at all. It is very clearly mentioned.
But I think partnership firm includes LLP registered under the LLP Act.
See, that may be under the LLP Act. The way
under the rules
are there.
Under the SBO rules, partnership
No,
includes
it is not
partnership.
there. You kindly examine that. It is not there.
Okay, if there is any point, we can talk to, we can refer it to ministry that this is confusion. Okay, so one more confusion in case of partnership entity is a member who is SBO and given a respect of individual or body corporate. If a society or trust is a partner, who will be the SBO? No clarity.
Correct. Same thing again.
Okay.
In case of a society is a partner or a trust is a partner, whether the trustee is there or not there, Ankit, I think he has mentioned this also, the clarity is not there. But by drawing an inference, one has to take the call and then file it accordingly.
Okay, and the same thing, we can ask the ministry also, what is the change in SBO? Is it altogether in individual or change in shareholding so far? So that can also be clarified by the
Correct.
Okay, now in the one example is, I think some people are giving so big questions, so I'm not asking this. If a friend of Mr. A facilitate the purchase by engaging an advocate, and as per the advice of such advocate, will he be liable under Benami Act in any manner whatsoever, Ashwini?
Look, if it advises like this, that this is a Benami transaction, you do Benami transaction, don't worry, then everybody in the chain will be liable. But if it is, in his opinion, it is not a Benami transaction, it is as per law, then of course he can put forth his defense. In that case, it will not be. So he should help in doing Benami transaction, knowingly that it is a Benami transaction. Only then he will be liable for prosecution.
Okay, Ankit, when there is a further addition of shares by SBO, then what would be the date of creation of SBO when filing the same on shareholding pattern with the stock exchange?
I think technically then there is an issue because the date of declaration will trigger from the date of creation. Date of creation will always remain the same when the actual date was there for the very first time. It is just an addition. So that is also one technical issue that will come while you file the change form.
Okay, Ashwini ji, if a person holds property in power of attorney of a backward class, is it Benami?
Look, the question is devoid of full facts. What is the purpose why power attorney has been given? if the power attorney has been given for the purpose because you could not have kept the property, bought the property in your own name, because this is what but this, you remember that attachment was done of property of Shah Rukh Khan, from where the people came to know about the Benami law, that not Mannat Wala Bungalow, that Alibag property of Shah Rukh Khan in 2017. And the reason was that in Alibag, he could not have bought the property himself because the natives could have bought the property. So allegation was, since you could not have bought the property yourself, you created a company, you took one native of that Alibag, that area, as your director, and then purchased the company director's name. And that is why it happened. Many parts of the country, the only natives can buy land. So if you want to bypass that rule and somehow you take the land in his name and then take over the control by taking the land in your name by way of power attorney, etc., then you may be in trouble, because exception for power attorney cases are given coupled with some conditions, and those two conditions have to be fulfilled. Only then. So, I mean, if you are exercising the full rights of an owner, not getting it registered in your name, you may be in trouble if you are not fulfilling the conditions of being power attorney holder. Now, somebody was asking me, sir, entire Knot Place is on power attorney basis. So what is the situation? The situation, you will be very, very sad to know, situation is that the entire Knot Place is prone to be hit under Benami law. And this was suggested by Law Commission in its report, Honorable Shri Virappa Moili's report, which was given Standing Committee of Parliament before induction of this law. He said, in case amendments are not done, 50% of India, urban India, and 60% of rural India may be treated as Benami. That is what is finding in 200 pages report of Law Commission. You can read it, it is on the domain. So, but government in its wisdom did not find it appropriate to make any amendments, and that is what the law is. Unless they make some amendments, many power attorney cases are prone to be hit under Benami law.
Okay. Sudhakar, ABC are subsidiary of X. There is a change in shareholding structure between ABC, and one shareholder is added, which is also 100% subsidiary of X. Do we need to report change in SBO even if SBO remains same?
See, though the SBO remains the same, the contents of the SBO when he has become, that is changing. So he has to file according to me.
Okay.
In fact, Pawan, let me also say one question very commonly I have been asked was, sir, my joint venture partner, despite the fact I am asking him, he is not giving me who is the SBO from his side. But still, you have to give notice under Ben 4. Tomorrow, if you want to protect yourself, you have to give notice under Ben 4. Still, if he is not giving the reply, then obviously you have to go to NCLT. There is no other way for that.
Okay. Ashwini, Mr. A makes payment to Mr. B to purchase an immovable property. A appoints his mother C as his constituted attorney to buy the property. If Mr. B and Mrs. C enters into a sale deed for the purchase of such property, would it be amount to Benami transaction?
No, facts are a little jumbled up, because if why C and B will enter into sale deed, you mean to say later on, after B buys the property, then B sells the property to C.
No, A makes the payment and B purchases the immovable property.
No, B is making the properties purchase, and A is making the payment of consideration. And if A is enjoying the rights as a true owner, if it is proved that possession is with A and the consideration has been provided by A only, then of course the fulfillment of conditions of 29A read with section 210 and 212 are fulfilled. So A becomes the beneficial owner, B becomes the Benamidar. So it will be now, if the facts are like this, then the consequence will be like this. If the facts are, say, A has given only a loan money to B, B is remaining as a true owner, B is exercising the rights of the owner, so then it will not be, because there is a recent judgment of Honorable Supreme Court also in the case of P. Leelavati from Justice M.R. Shah. He says mere providing of finance will not tantamount to leading to a Benami transaction. So there has to be distinction between the intentions of the parties have to be seen, whether it is a finance transaction or whether it was intended to be providing the consideration for own personal benefit. This distinction has to be kept in mind.
Okay. Okay. Somebody has commented, Sudhakar and Ankit, definition of partnership entity under SBA rules includes LLP 2E. So
Okay,
that is the.
I stands corrected then. I stands corrected. Yeah.
What is the Sudhakar, if any individual has SBO and does not disclose to the company, now you have a lakhs of lakh shareholder. Now, if they are not disclosing, how to get the information?
See, as I told you, first of all, an individual is holding more than 10% or not, we have to see that as a company secretary of our company, any company, we have to see that. From where I will come to know about it? Obviously, I have to see my ROM. In the ROM, when I am looking at, I have to look at the possibilities of his becoming an SBO, not individually, even sometimes it may be together with others also. So for example, whether it is with the body corporates, say for example, the body corporates having the same group name, they might be having maybe about 10 folios. Then I have to club all of them together. So what I will do is I am going to issue a notice to them under Ben 4 that as per my ROM, it seems that you are the SBO holding more than 10%. You are not filed the Ben 1 so far with me. So kindly, then I have to draw the attention of him to section 90 provisions and the rules thereof. If he is still not giving or giving an evasive reply, if I am not satisfied with that, I strongly believe that he is the SBO but not filing the declaration. Then I have to file that matter with NCLT. Then he has to go and contest it that he is not an SBO and all. That is a different thing. Otherwise, I will be held responsible as the company secretary of the company. And not only it is the responsibility of the company secretary, even of the board also, because it is the company's responsibility to identify the SBO.
Ankit, 89 and 90 is applicable to private limited company also?
Yes, it is applicable to every company.
Okay. Ashwini sir, a very interesting question has come.
Yes, sir.
Can you explain fundamental right of having and holding and enjoying property?
Having a property is a constitutional right, not a fundamental right under Article 300A. But any right which is a constitutional right is subject to certain rules and regulations. So even a tenant who is bound to be evicted, he may also say, I mean, this is my fundamental right. Since I am a tenant, nobody can deprive me of the property. Suppose somebody has made the property on the roadside, somehow it was passed. So fundamental, these constitutional rights are subject to the laws which are above that constitutional right. There are somebody else's right is also there. There is a government right who wants the clarity. So I mean, you cannot have any constitutional right for wrongdoing. If something is contrary to law, that is wrong. So Benami transactions have been allowed expressly by the law, by section 81, 82 and 94 of Indian Trust Act and section 281A of Income Tax Act. If the law expressly said you do Benami transaction, but in 1988, they were repealed. So if the government repeals, the government is in supreme wisdom, can do anything. We have to follow.
Okay. Ankit, private trust holds shares, trustee's name is entered and registered owner on behalf of trust. Should they again declare SBO under section 90?
While their name is already entered in the register, I think still it should be required.
So you have any different view?
What is the question, Pawan?
If private trust holds shares, trustee name is entered as registered owner on behalf of trust, should they again declare SBO under section 90?
Yeah, see that first of all, when that trustee's name is registered in the ROM, first and foremost thing is they have to file declaration under 89. In addition to that, if the trust is holding more than 10% of the shares, if it is a discretionary trust, yes, the trustee will become the SBO and he has to file a declaration under section 90 also.
Okay. So last two questions and then we will close it. This question is, Ankit, X Limited has been incorporated by Y Limited as a wholly owned subsidiary with 6 nominee shareholder holding 1 share each, which is mentioned in the subscription sheet of MOA and AOA. The question is, holding 1 share as nominee shareholder of Y Limited, since already information is provided in ROC, MOA and AOA, do we still need to file Form MGT 6 with ROC for intimation of beneficial ownership or nominee shares?
I think it should be, sir, while different practices are being followed, but it should be filed. And I think in the new structure, where in the form, you're not disclosing the name as the nominee, you're just mentioning the name. Nobody can find out you're acting as a nominee, but nobody is going to see the memorandum. So it is prudent that you should file the form.
Okay.
I agree with Ankit. What he says is correct.
How will SBO be identified in case of trust is a member of a company? Sudha.
I think that was.
Yeah. Go ahead, Ankit.
It was mentioned, and we discussed this, sir. If it's a specific trust, then the beneficiaries will be the SBOs. In case it's a discretionary trust, then the trustees will be the SBOs. Even in case of a discretionary or specific trust, if it is a revocable trust, then the author will be the SBO.
Okay, okay. So I think we have accept some few very big questions, which has multiple example, which is not, if I have to explain, then facts will also not reach to you properly. I have left out, but most of the questions we have given answer. But even if any question is left out, please separately write to us, because some of the questions we have given answer in the presentation. Some of the questions we have given answer in a different manner in different questions. So even still some questions are unanswered, you can write to us. Ashwini sir, Sudhakar and Ankit will reply to you, and we will send it to you the reply. So I think it was very wonderful experience which we have seen. And the most important thing which has come out, that everybody should realize this, that this SBO concept is not something which is coming out in India. It is worldwide. If you are going to incorporate a company in any part of the world, they will ask who is the owner. Whatever structure you can create, they want to reach to the natural person. So the natural person should be person, not the companies only. So they want to reach out that whether Sudhakar is the owner, Ashwini is the owner, or Ankit is the owner. Whatever Jangwala we have shown, I have shown, Ankit has shown the one slide, which was just like a electric chart of any building. That is a chart of one company, which we have done the audit, that how to reach who is the owner of this company's shareholding. So this is one aspect. And we remember when last time election has taken place, then one newspaper has given this assignment to us, and he has asked us that please give me the structure of various political parties. So in the process, we have identified various companies. He gave the link that this is the company's name, and this person is the owner of this company or holding shares. So we have reached with the same chart, same style, this company to that company to this company, and how to reach, and we have reached to this level also. So this is a very complex system. Government wants that whatever complex you can keep it for income tax purpose, but ultimately you have to disclose properly that who owns this company as a natural person. That is the basic law. And Ashwini sir has given a very right answer to all these things. Whatever structure you can make, the structure should be legal, number one. Second, the structure should be opaque. The structure should be very transparent. It should not be that something which is not visible. So I think the basic issue, if it is clear to all, then all answer which you have asked, the change in person, change in number, change in structure, percentage change, class change, everything is changed. If the crux is that if you have to disclose certain things, you have to disclose, don't hide this. Even if you are disclosing some additional thing, it is not any harm to you, you can do it. So basic, just I'll give you 1 minute to each, all three speaker, and they can summarize it, that in today's program, what is the message you want to give relating to this topic which we have come out. So that.
Yeah, I only say that when you are in doubt, disclose. That is the mantra for listing regulations as well as the Companies Act also. The company secretary is having onerous responsibilities on him. So unless until there is a big issue is there, that doesn't mean I'm not saying that big issue is there, you don't disclose it. Still you have to disclose it. But only thing what you have to do is do your homework properly. Section 90 is the most draconian section according to me under the Companies Act 2013. Very complex, but at the same point of time, if you spend enough time to understand that, it is not that complex also. Thank you.
Okay, Ankit.
I think the overall concept of SBU is to find the true owner, and while determining, one should rely on finding on actually the person who is in the overall control, who is taking the shots at the top of the hem of affairs of the entire group. That should be the legal basis for determining. You may have created various complex structures to hide these and this person, but the purpose is to unhide this person and bring this to light, as mentioned by Sudhakar ji. So purpose is to keep in mind that person who is taking all the shots at the end of the day on the top of the group should be disclosed.
Ashwini sir.
I will divide my final comments in two parts. First of all, as far as SBO is concerned, we have discussed that it is the duty to be transparent. All right. But one thing we are forgetting, one very, very crucial aspect, and for which government should also remember this thing, that ultimately our privacy is getting exhausted, totally finished. So by becoming more and more transparent, all right, we are helping the government, but there are in businesses, there are some exigencies, there are some confidentialities, there are some other compelling requirements to withhold the information, not to conceal, but to withhold the information for some purposes. So that if the information is spread like this, maybe the requirement of the businesses would not be met and there may be some problems therein. That is one part only. I'm not suggesting for wrongdoers to perpetuate the practice, but this is for the government to also ensure that how that it will ensure the protection of the people. That is one part. As far as Benami law is concerned, I try to connect Benami law with our life. Actually, what I say, what probably this law is suggesting us is that now the way we should live is what we think inside we should portray outside the same fashion. What we believe ours inside, only that we should tell others that it is our side, ours outside also. And that is what we believe outside also, that it is ours only. So in a way, live real life and get rid of Benami life. That is how you live the life wonderfully. Thank you very much.
Thank you, Ashwini. Thank you very much. Thank you, Sudhakar ji, Ashwini ji, and Ankit for giving this. I just want to inform everybody, the Ministry of Corporate Affairs has notified Section 211, Section 18C, Section 22, 25, 27, 53, 55, 58, 62, 64, 65. All are operational now. They have given the notification of the CSR amendment rule also. They have notified Section, they have notified Section 21 of the said Act is also there. So this is when we were discussing, it has come. So friends, now what we will, I thank all three panelists for this program and all the participants who have patiently, they have heard the discussion, their answers. So I thanks all three panelists and thanks to all participants. See you next Friday at the same time with a new topic, which we are working out with so many changes are taking place. There is one change is taking place, direct listing of unlisted company without listed at Indian Stock Exchange. You can list at any stock exchange in the world. That is coming, and I think they are notifying shortly, or they have notified in this. So we have to check this, and then we will inform the next program on Monday morning.